So some people always want to know, what can I do and how can I prepare to come have a meeting with a lawyer? The best thing that you can do to have your first meeting or your initial consultation with your lawyer is primarily to bring your financial information with you. Those are going to be the documents and the things that a lawyer needs to be able to give you the counsel that you're expecting at that initial consultation. Generally, a pay stub for you, a pay stub for your spouse, maybe your tax returns, any documents that you can find, particularly before anybody files. If you're just kind of thinking through things and thinking through what it is that you wanted to prepare for, it's important to kind of go find those documents and find that information before something gets started, because you never know when things might go missing and you may not be able to find them again. So looking for those specific documents, trying to get a good idea of what your assets are, if you have an ability to do that, whether you can find a balance sheet or a financial statement of sorts, but your retirement accounts, your bank accounts, kind of just knowing what all of your initial information is. Almost every jurisdiction has a standard domestic relations financial affidavit that each party will have to fill out and swear to, that says these are all of our assets, these are all of our debts, and this is what my income is. And those things are used by a judge to determine child support, to determine alimony, and to determine equitable division. So if you want a kind of guideline of what kind of things you need to be looking for, you can usually pull up on any clerk's website that domestic relations financial affidavit, and it'll give you a breakdown of all those documents that you should be looking for. Now, whether a lawyer is going to actually go through all of them with you at that initial consultation kind of depends on the facts of your case as you come to see them, but it's helpful to have them to just give a ballpark, because otherwise we can't really give you a ballpark for what child support will be, or for what alimony will be, or for how your assets could be distributed. Also, if you've got assets that have been in your name or someone else's name, or you've gotten gifts via inheritance or trust or those sorts of things, it's helpful to go ahead and start trying to locate those kind of documents that are going to indicate how a piece of property originated, where it came from, how it was purchased. All of those documents are important, and it's easier to go ahead and start getting them, because sometimes those things can take time. Generally speaking, a divorce case, a contested divorce case gets started by somebody filing a complaint. That complaint is served on another party, and once it is served, that individual has 30 days to answer that complaint. From that point forward, discovery takes place for a period of about 6 months, and that's when everybody gets information from the other side. Sometimes in the middle of that period, a judge may order you to mediation. It may require that you guys sit down and try to resolve the case. But after that discovery period runs, which is about 7 months from the initial filing, is when your case could be put on a trial calendar. Now, that's not often the first time it's on a trial calendar, but that's typically the time frame. So sometime between 7 months to a year, if you're really going to fight a divorce case, is where you're looking at having it actually be heard by a judge.